Good morning.
Good morning.
This is the Metropolitan Board of Ethical Conduct meeting of April 29, 2024. It is 9:02. I sense a quorum, so I will call this meeting to order and ask our Board Secretary to take the roll.
Chair Diani,
Present.
Ms. Carpenter,
Present.
Ms. Grimes,
Present.
Mr. Spraggins,
Present.
Ms. Young,
Present.
Mr. Gutierrez, and Councilmember Suara are not present.
That brings us to the second item, which is public comment period.
There's no one signed up.
And there is no one signed up for public comment. That brings us to item 3, approval of the minutes of our April 4th meeting. The minutes are in our package. I hope everyone's had a chance to review them. I will, they're clear and extensive, so thank you for putting these minutes together. Is it Mr. Yeah, thank you. So may I have a motion to approve the minutes?
So moved.
May I have a second?
Second.
Any discussion? On the minutes? I will give our member who just arrived a moment.
Sorry, someone stole my bike.
Oh,
Kind of painful.
okay. We're just on agenda item 3, the minutes, which are in the packet. Any discussion of the minutes? Hearing none, why don't we do approve the minutes by voice vote? All in favor, say aye. Aye. Any opposed? Hearing none, the motion passes to approve the minutes of April 4. That brings us now to the notice of the appeal rights for our board action. I'll ask Mr.
After a contested hearing by this board, a party may appeal to the Chancery or Circuit Court of Davidson County by filing a writ of certiorari within 60 days. Any party wishing to pursue an appeal is encouraged to seek independent legal counsel to ensure that deadlines and procedural requirements are satisfied.
Thank you. Okay, that brings us now to item number 5, which is the hearing on the complaint of Yosef versus Cheek, former Arts Commissioner. To start this process, I will confirm that the parties have received our hearing procedures of this board, and they've had an opportunity to review them. They were provided to the parties briefly, and we have some new members here of our board that haven't been through this process again, so I'm going to take liberty to just bullet our process, our hearing process. The order of proceedings we call the hearing to order. We see if there's any preliminary matters such as motions or stipulations or agreements, and then we move to opening statements. A party may, but is not required to provide an opening statement. If there are opening statements, the complainant would go first, have the opportunity to go first. There's then a presentation of the evidence. So the complainant would go first and present the complainant's evidence with the opportunity to call witnesses, ask questions of the witnesses. The respondent may cross-examine the witnesses. The complainant then may ask follow-up questions or redirect, and the respondent can recross. Then the respondent puts on their case, and it's the same opportunities for direct exam, cross-examine, redirect. And then there is rebuttal. After the respondent rests, then there's a chance for rebuttal. And then there are closing arguments. Again, an option to close, not required. We do have a burden of proof, which this board, several years ago now, adopted as a policy and procedure of this board. The standard we're using is preponderance of the evidence. Many of us are lawyers on this board, but we don't want to be overly legalistic and use legalistic jargon. Preponderance of the evidence just means more likely than not. So that's how this board functions. It is the board discretion, and make sure board members know that the board members, we may limit the number of witnesses and time permitted to each party to present evidence and argument, but I don't know if it says it right here. Board members may ask questions of any witness. And legal counsel is here to assist us if we need to make a request for information. Okay, so that's how we will proceed today. We have, just to focus the board members on the packet in front of us, we have the standards of conduct right in front of us. Okay, so that's number 2. I want to also thank the clerk's office for putting such a good package together and organizing it so well, so it's very helpful to us. Okay, so we have the original complaint by Ms. Yosef. We have the legal department's memo, and we have material submitted by complainant for this hearing, and we have material submitted by the respondent. All of that is in front of us. Okay? Any questions of the board in terms of procedure? Okay.
I have a question.
Yes.
Are we going to establish time limits on the front end as a board? That was one of the provisions, or?
I think not. Did you have a suggestion or proposal?
Well, I was just wondering in terms of setting expectations for the complainant and the respondent so that they can organize themselves to fit within the time, but I don't know what's appropriate.
I think that's appropriate. Do you have a proposal?
I don't have a proposal.
I mean, we usually, in some ways, the purpose of this board is to provide that place within Metro, the community board, appointed by community organizations, a space and a place for people to speak and have their kind of day to explain their concerns.
Yeah.
And then equally ample opportunity to respond to concerns stated. So, but I think, do you have any recommendation of the amount of time? Half hour? 15 minutes? I mean, does anyone have any view of that? Because I think it's a fair question.
Yeah.
I don't want to be overly restrictive. That is definitely my view. People we know that complaints are brought because of that are important to the individuals who bring them, the members of the public who bring them. And there's a lot of preparation that goes into it, so I certainly don't want to cut short anyone's opportunity to present their case or to respond to the case. Yes?
If I could make a suggestion,
Yes.
you might ask the parties or the representatives how long they think their
Yes,
presentation
thank you,
is.
very good. I'll start with Ms. Yosef. Do you have any sense of what, with your witnesses, what the total time would be to present your case in chief?
I assume 20 minutes.
20 minutes, okay. And I'll ask,
5 minutes to be fine.
Okay, all right, so is that, okay, super. Okay, well, thank you, that was very clarifying, and thank you for the suggestion. Great, okay, that said.
I have another question.
Yes.
I will likely have to recuse myself from item 5 and 6.
From what?
Items 5 and 6 on the agenda, because the the funding allocations is more outlined, is more direct towards my organization that I run.
Because the funding
Yeah, it affects my organization.
allocation. So you're going to recuse yourself from number 5 and 6?
I think so. Yeah.
Okay.
I tried calling to see if I needed to call.
Say that again? I'm sorry.
I guess with that, do I need to be here for the rest of the?
There could be, I don't want to.
No, go ahead, no.
There may be other items on the agenda that,
Yes.
business that you
There-
have.
There are other items on the agenda. So
Okay.
Sure, my preference would be that you stay, but I also realize your bike was stolen. I don't know if that requires
No, it's
immediate action on your part.
I'm not gonna get it back right now.
Okay, so are you able to stay?
Yep.
Okay, but you are formally recusing yourself on items 5 and 6?
Yep.
Okay, so the record shall reflect. Okay, that said, we still have quorum. And enough for action, enough members present for action. So any other questions or comments? Hearing none, I will now call this hearing to order and ask if there are any preliminary matters, motions, affidavits, not affidavits, stipulations between the parties that need attention before we go into the complainant, the opening statements. Yes.
Chair, I do not have a motion, but it would be helpful to me if we could get some clarity about what exactly the evidence and witnesses, what is material to the one question that's before the board. It might save the board some time if we could narrow the scope of what will be considered relevant.
I think that will, so an order has been issued in this case on, I think, April 5th. And the parties have the order. And the order is express that we are focusing let's see which one is number 5's the order. We are focusing this hearing on the standards of conduct, sub-paragraph O, which may make sense to read into the record just as we begin this. So what this hearing is looking at is the one count that was sustained and we're moving forward to hearing on is consideration of whether former Commissioner Cheek violated subparagraph O of the standards of conduct. Subparagraph O reads, shall not accept other employment or engage in outside activities which might impair their independent judgment in the performance of their public duty. That is the question we are looking at. That is the question we will take evidence in. That is the question we will then determine based on a preponderance of the evidence. Okay. Any other preliminary matters? Hearing none, then we can move to opening statement. Ms. Yashab, would you like to make an opening statement? Okay.
I don't have a mic or anything? I'm just supposed to speak?
It's a small enough room. I think we're okay. And I think the mic is, the whole room is mic'd actually, right?
Yeah.
So it will pick the video will pick up your voice.
So I want to thank the board for hearing this complaint, first of all. I thank you all because you are volunteers, and I know it's a lot of information and a lot of decades of issues in this commission that's coming down and culminating in 1 month. So I want to thank you for reading through the material and taking your time with us today. I did want to say I entered this process assuming that it was a sensible system to bring an allegation, have a discussion, and see what can be done civilly and without courts and lawyers to rectify a dispute between a community member and a government official or volunteer person. Unfortunately, I do not think that this is the system that it is. When I asked Clerk Austin Kyle for what protections are afforded to a complainant in a whistleblower policy after scoring over the board's documents. He said that this question was outside of the scope of the board's procedures and laws, and I'm not, bringing it up just to say anything about you, but I just think that that's something you all should think about as a board, about the safety of complainants when they come before you, especially when the other side is lawyered up and you cannot afford a lawyer and you don't have time and capacity, nor do you come from a community with many lawyers at all. So I just wanted to bring that up as something that's inequitable. I'm still here today despite the legal conflict that I've put myself in possibly, because I believe what Will Cheek has done is wrong and has deeply, deeply harmed so many community members in Nashville. And that every commissioner should learn that with power comes responsibility, and with responsibility there are consequences. I'm also here today so that community members know that despite this board system, because it does not acknowledge people who are not familiar with the system, I did not have a lawyer present during the discussion. Will Cheek did, showing his familiarity with the system and my lack of it. And because the system does not consider or even imagine community members who can't afford a lawyer, can't seek a lawyer, don't know lawyers, I'm still here today for the community. So before I begin my argument, I just wanted to make it clear that I am not a lawyer, I cannot afford a lawyer, I was not afforded a lawyer, and I have not been able to even consult a lawyer for this case. So, with that, I'm going to start the opening statement. I did want to read from Attorney Jamie Holland's letter to the commission he's a lawyer, so he succinctly put it together what's been going on to give kind of a brief overview in case it wasn't noticed in the material. So Jamie Holland writes, this was on April 24th, 2024. He writes this to the commission. Prior to, I'm gonna fast forward. First, Nashville Arts historically operated as a proverbial washing machine. Taxpayer money was put in the proposed budgets by various administrations and appropriated by the Metro Council to Nashville Arts to flow to legacy institutions historically receiving taxpayer funding. According to the MHRC report, over 71% of funding to Nashville Arts from Metro taxpayers went to institutions with annual operating budgets exceeding $1 million, 71%. Until Director Daniel Singh was hired as director and led the commission to commit to equitable funding, no one in the Department of Finance cared much about the functions of the arts. In other words, it was working as intended, taxpayer subsidies to wealthy institutions on the backs of others who were compelled to pay. What's really going on here is that actors who've been historically propping up these funding inequities are upset. Their feelings are hurt.
Excuse me, are you reading Mr. Holland, Attorney Holland's, you're continuing to read?
Yeah, I'm just gonna read his contextualization of what's going on.
Is it in our materials?
It's not, because he submitted it on the 24th instead of the 22nd.
And he's not a witness?
He is not, but this is a public.
Yeah. Okay, all right. Okay, well, keep reading then.
Okay. What's really going on here is that the actors who've been historically propping up these funding inequities are upset and their feelings are hurt. The most likely reason for anger is simple. Moneyed interests don't like it when they don't get their way. Back in 2021, the prior administration put $15 million in the budget to build a parking garage, think capital, not operational taxpayer funding, at the Nashville Zoo. This sent a clear signal to other institutions receiving taxpayer subsidies that the prior administration would indeed open taxpayer coffers for the first time capital needs. Rewind to the last budget of the prior administration, as you might recall in my initial email to you back in March, to them being the commission, March 7, 2024, wherein I stated, in the prior term of the council when adopting the budget, aka the law, an amendment was made. The language of the original budget from Mayor John Cooper set aside $2 million in anticipated surplus funds from capital grants for cultural support, quote unquote. The council, in its wisdom and powers, changed that to funding for cultural support in the amount of $2 million. The council didn't comply with this attempted budget appropriation. Instead, the money was awarded based upon a rubric or process crafted by Director Singh, arts staff, volunteers, and the broader arts community, and later adopted by the commission in July of 2023. So, not only were the capital desires of these institutions thwarted, but they also lost some taxpayer operating subsidies for their troubles because of the council appropriated and commission approved Thrive Awards were distributed to ordinary artists and they're livid. Instead of taking their collective anger out via the election process when a new council and mayoral candidate were on the ballot, they needed a scapegoat. So I just wanted to give the background of what happened during that vote. So, and the conflicts of interest that were impacting that vote and that 2 million. Now I'm going to transition to the MHRC Title VI complaint. I'll have Ashley speak at the end of this, but I'll just bring up my points now.
I just to clarify.
Yes.
So we're in the opening statements part, and then respondent would have an opportunity to make an opening statement. And I don't want to have the opening statement blend into your case in chief, so I don't know where we are.
Chair, if it will help, I'll waive an opening
You're
statement.
going to waive your opening statement? Okay. Okay. Then now you are in your case. You're done with your opening statement, and now you're making, this is your case.
Yes.
Okay. That is focusing on former Commissioner Cheek and, the paragraph. Okay. And you will be calling witnesses?
Just one.
Just one?
Okay.
Okay, thank you.
So in the MHRC report, not considering those 4 categories, Commissioner Cheek is the only commissioner with an inconsistency in recusals and abstentions on his vote for mid-sized organizations between meetings. In an interview, he disclosed his conflict of interest due to a relationship with 5 large organizations: Belcourt Theater, Cheekwood, Nashville Symphony, Country Music Hall of Fame, and the First Art Museum. His on-the-record disclosure includes Oz Arts, a mid-sized organization from which he should have recused himself from in the August vote, as he did in July. In other words, Will Cheek voted to recuse himself in July of 2023, but did not in August of 2023. It's a very narrow allegation and it's very straightforward. I believe his legal counsel from the letter that I read has failed to refute the inconsistency in the recusal from July to August 2023, because even if he had stopped operating with Oz Arts for 2 years, as Cooper alleges, why then did Will Cheek recuse himself in July of 2023 for mid-sized organizations? But Will Cheek's attorney has introduced a new issue 2, which is presented in the material I offered you in this hearing. It is the issue of Cheek's inconsistency in reporting his conflicts of interest, most notably during the December 14th, 2023 special session with the Metro Council Arts Committee. I have the timestamps in the material, held by Councilmember Joy Stiles. I will read from the transcript that I transcribed starting at 59 minutes and at the 35th second. Already during that meeting, Director Daniel Singh of Metro Arts had been questioned, and Director Davey Tucker had been questioned by the committee. And Joy Stiles at this point, Councilmember Joy Stiles, turns and asks Commissioner Will Cheek to speak. So I'm going to read from the transcript. Joy Stiles says, earlier there was mention of conflicts of interest, asking if people are sitting on boards of large organizations and also sitting on the Arts Commission. Is that a conflict of interest for you that you've run into at all? Will Cheek, I think arts commissioners by and large are involved in the arts community, whether they know artists or art or perform, or in my instance, served on boards. We all have interest in the arts in one way or another, and that's part of what we bring to the community. So when we have a vote that impacts something that an arts commissioner personally participates in, they recuse themselves. That's been the policy, and that's what Metro Legal told us to do. Joy Stiles, and do you serve on any of the boards that have filed any of the complaints or the concerns, I guess, of not getting any funding? Will Cheek, I do not know any of the artists that have complained. Joy Stiles, I'm sorry, I may have worded that incorrectly, but the larger organizations that have been getting the lion's share of funding, I guess, are the Nashville Ballet and TPAC along those lines. Are you affiliated on the boards of those organizations? Will Cheek, I act as legal counsel to a number of nonprofits, and yes, I give legal advice on a pro bono basis, not paid, to a lot of nonprofits. Joy Stiles, of the arts. Will Cheek, a lot of arts groups, yes. Joy Stiles, okay. Will Cheek, from the Nashville Children's Theater to, I don't know, a bunch of them. So I want you all to focus on the inconsistencies in his reporting and ask yourselves why there is so much inconsistency. First, Will Cheek, during this just small segment, maybe 2 minutes, within this special session, he mentions the Nashville Children's Theater, which is a mid-size organization, according to Metro Arts, that has received grants for years from Metro Arts. Nashville Children's Theater was not mentioned in Will Cheek's conflict of interest or recusal disclosure form, and he voted on their behalf in July and August. Secondly, Will Cheek claims to be a board member and served as such to multiple organizations without naming them. Later, he says he's been legal counsel to several organizations. To me, this is a big difference between legal counsel and a board member. Specifically, even though I know they can overlap and a lot of nonprofits have legal counsel, a lawyer on the board, the role of a board member is to fundraise in many ways. So, especially if it's on the issue being that a board member's role is to fundraise, and then this board member is on the commission that delineates money, taxpayer money. And secondly, legal counsel subjects him to attorney-client privilege, which is different from being a board member, and I think could take some investigation as to the attorney-client privilege between those organizations and legal counsel. So his inconsistency in naming whether he's a board member or legal counsel and the implications between those two titles, to me, is distressing. And then thirdly, Will Cheek claims to be connected to the art scene in Nashville, but does not know the complainants of the Title VI complaint. Nor has he engaged with the complainants who are alleging to discriminatory funding practices. Despite these complainants having performed at the Frisk, TPAC, and the Opera and have struggled for equitable pay at these institutions. So it would have been more accurate for Will Cheek to say that he is connected to middle management at museums and concert halls. That's very important to what happens in August, but not that he's connected to artists and the creators within the Nashville community and what that implies for the funding allocations, because he's funding middle management and not artists, and specifically chose to defund artists. So I really want you all to focus on those inconsistencies. I will also say that Will Cheek's recusal is not that he hadn't worked for Oz Arts for 2 years, but rather the issue is that his inconsistency with disclosing and also with the voting between July and August. I will also say that there is an example from the MHRC report in which he is quoted saying that he spoke to, I don't have it quoted here, so I'm going to paraphrase, but it's in the MHRC report, that he spoke to a friend at the Opera, a board member at the Opera, before this vote took place to defund the artists and fund middle management. So as you can see, the Opera...
I'm sorry, what are you
The
paraphrasing?
Nashville Opera.
No.
Oh.
What are you paraphrasing from?
There's a quote in the MHRC report in which I'll ask Ashley about it, so Ashley can bring it up. Sorry, Ashley, for adding that to you, but in which he says in that interview with MHRC that he, before this vote, had spoken to a friend who was a board member at the Opera. So someone may say, okay, but it was a mistake. Let's just say it's a very small, minor mistake. I don't think so. Will Cheek is a lawyer. He served on the Arts Commission multiple times, and he served on multiple boards. He has high connections to government, as you can tell by the lawyer he's retained, is John Cooper, the former director of Metro Legal. And moreover, there were multiple times where he could have documented his conflicts of interest beyond the form that commissioners are supposed to fill out as well. So I'm going to name all 5 of the instances where he could have named all his conflicts of interest. I also put in the timestamps for the August 2023 defunding vote, specifically where that vote happened and the conversation that happened. So first, Metro Legal, I'm told, does a training on conflicts of interest for all boards and commissions. That was one opportunity. Second, in his interview disclosure to be a commissioner. And third one I'm going to get to here. During the August 2023 defunding vote, Commission Chair Powell, who is a Black woman who resigned immediately after the majority white commissioners voted to defund local artists, says at 1 hour, 14 minutes, and the 25th second, So, this is the opportunity, if you remember seeing the list of people in each group, that if you have a conflict of interest, remember you recuse yourself from those votes. If you are affiliated with any of those, and I think this must be, so they have on a big projector during this meeting that you can't see in the video, a huge projector with all the names and all the conflicts of interest. So it's right in front of them. They had received a form prior to this vote as well, and now they're double checking on the projector. So she says, and I think this must be the conflict of interest that they're putting up here. So thank you. So everybody can recognize what they are based on the forms we filled out. After Commission Chair Powell clearly indicates how recusal works, votes on funding scenarios occur starting with Thrive, then the micro, and moving up to the large.
Excuse, are you speaking of the July vote right now?
August.
This is the August vote?
Yes.
Okay. Okay.
Where he doesn't recuse himself. So he sees.
Okay, but what you're reading, telling us about now is the August vote.
Yes, ma'am.
And are you saying this happened prior to the beginning of voting?
So so this, after they voted.
Because that was
So
what I
they filled
understood,
out a
that there
form.
wasn't, right, but
Yes.
they had started voting
Yes.
before they were reminded.
Yes, so Metro Legal asked them to resend, they resend all those votes, they
No,
then.
I'm within, continue, I might ask your witness to clarify. But you are intending to tell us this, what you're telling about Chair Powell and the projector is from the August 23 meeting, okay.
And then they go all the way up to large. After they finish all the conflicts of interest, and after voting on those allocations, Commissioner Janet Kurtz asks at 1 hour, 20 minutes, 41th second, point of clarification, abstention is different than recusal or the same thing? Commission Chair Powell says, I don't know, ask the legal people, referring to Metro Legal. Tessa Ortiz Marsh says, who is the legal counsel for present at this vote, says, is abstention different? Yes, and then full halt. Will Cheek then unmutes, pulls the mic close to him and says, if we're recused, we don't vote at all, clarifying for Commissioner Janet Kurtz. He then unmutes himself and then says, he leans over to Janet Kurtz, who's right next to him, and says something, and they both laugh on the video. So this was the 5th opportunity where it's very clear he's awake, he knows what he's doing, he's saying he knows what recusal is, and he's even clarifying for another commissioner about the implications. So someone may say, fine, it was a small mistake, the impact is still the same whatever the decision of the board, and I will disagree there too. Will Cheek has served on several boards, and unfortunately, there was a resolution, as I shared in your packet, to remove him because of the conflicts of interest and because of multiple decisions that he made outside of that. Because he chose to resign, there is a possibility for him to return without it being obvious on his record. None of the media have really covered what he has done, and many media sources have even painted him in a favorable light. It's only the MHRC complaint that sheds light on what happened. Because of this defunding, I want to share lastly the impacts. I could wait for the closing. Would you prefer
Okay.
that?
Yeah, I think so.
Okay. Then I'll just end there.
Okay, super, thank you. Okay, so where we are right now procedurally is there's been closings, openings have occurred, and you're presenting your case. Now, you may call a witness. If you have a witness to call, then this would be the time to call your witness and ask questions direct. That witness then would be subject to cross-examination, and any questions that the board may wish to ask the witness.
So I'm going to call from the Metro Human Relations.
Okay.
I'm going to call up Ashley Batchelder.
Okay.
And
Before you start, she needs to be sworn.
Oh,
Do you solemnly swear or affirm that the testimony you're about to give is the truth and nothing but the truth?
Yes. Do I just say yes?
You say yes, yes.
Yes, I do.
You may proceed.
so I'll just ask you to introduce yourself and introduce how the MHRC complaint came to you and what you were researching.
So, Good morning, everyone. I'm Ashley Batchelder. I am the Director of Policy and Research at the Metro Human Relations Commission. And I served as the primary investigator and author of the Title VI report that I know was submitted in the materials that you have, and I know has been referenced a lot throughout this. And so I was asked to come speak a little bit about the specific parts in the report as they relate to the allegation before you, and just to answer questions to give a greater understanding to the report. And so I am speaking in this role, in this, professional duties of my job, as I've been engaged in this since October of 2023. And I also just want to say that the MHRC report, we were very clear in our conflict of interest section that we are not the agency that adjudicates what is a violation and what is not. That's obviously why we are here today. But what we did do in that report was collect and review information from public meetings or public documents, department policies, and did individual interviews with commissioners and other stakeholders. And so I'm prepared to sort of explain what those things are that we reviewed as they relate to the complaint.
And this, just for the board, this is section 5 of your report, starting on page 44. Is that the section that we're focusing on?
Yes, and I think there was a question, or a clarifying question that I think was asked to Lydia, which is in section 4, but yes, primarily the conflict of interest section.
Thank you.
So I'm going to ask you, can you speak to the material that you found about conflicts of interest?
Yeah, so what we did was kind of look at, what's everything that was on the record, what are things that we had conversations with people about, and so as they relate to conflicts of interest. And so the first thing, and I'll say, I don't know that this was submitted as evidence, but it's part of my report. So,
And it's before us.
okay, so this is just the boards and commission application form that all commissioners on any board and commission complete when being considered for one of these seats, so in that nomination process. And so one of the questions is describe any potential conflicts of interest your appointment may present. And so when Mr. Cheek filled this out on January 12th, 2023, it just says NA. So I'm not sure if he wrote NA or left it blank, but it's an omission of any information there.
Is that attached, is that specific document attached to your report?
So the way it is in the report is that I use these primary sources to create a table in the report, which is
So why don't we just look at the table then?
Sure. So that is on page 48. No, that is on page 45 of the report. And so table 4, commissioner interview and questionnaire summary. The questionnaire is the questionnaire that nominees submit to the council for their approval process. And so the title of column 2 there is disclosed conflict of interest on questionnaire. Mr. Cheek put none. And so again, I'm just reviewing the information that we reviewed as to what is on record about these things. So any questions about that?
It's page 44, Chair.
Yeah,
I mean, sorry, 45.
No, I have 45, but I guess elsewhere in the report, and I believe in the complaint, I saw interview disclosures and quote, on the record disclosures.
Yes. So I'll say I'm about to tell you 3 things that I reviewed. So this is number 1.
Okay.
Number 2 is what did Mr. Cheek submit to the staff of the department for their department-specific policy.
Is that what on the record means?
Yes. And then what did he tell me in an interview? So those are like the 3, corroborating our sources as I'm writing my report. Does that make sense?
So 45, column 2, disclosed COI on questionnaire. Was
Yes.
that your questionnaire?
No. So this is.
Here's the form when you're appointed, the formal form that goes to the commission staff, that's on the record?
That goes to the Metro Council and the Metro Clerk.
Okay, for prior to appointment?
Yes.
That's what's on the record, what you
It is
disclosed?
part of the record, yes.
Sorry, this is before the on-the-record one that she's talking about.
Okay.
This is when he was appointed.
What do you, that's what the questionnaire is?
Page 45.
So 45 is when he's being considered for appointment?
Yes, so he
Okay,
had
in
completed his
January.
first term of service and he was going up for confirmation of his second term of service. And so part of the process that commissioners go through, and I believe the clerk facilitates this process, is the collection of these questionnaires.
Yes, okay. It was for his second term. He had already,
Yeah, and I'll say, I'm sharing this because I'm sharing what's relevant from the report, my report.
were you able to look at the, any disclosures from his first term?
I do not have the first term.
So we don't know what he disclosed on when he was initially appointed. We do not know what he disclosed.
No, and that would have been in 2019.
Okay.
Yeah, so I don't have that source.
So that
But-
wasn't looked at, okay.
Yeah.
Okay.
And so that was, just the first thing that sort of source that I reviewed in just providing information. So the second source that I reviewed is described on page 48 of the report. And so the one that I just mentioned was sort of what I refer to in my own words, like the centralized process. Every board and commissioner submits this. But then in your department or your commission, the Arts Commission has a process that they use. So that process is that once a year, they self-report what conflicts they want to have on file with the department. And so that is submitted online via a platform called Submittable. It's just an online, survey, essentially. And what that question says, I'm reading it, quote, "Please list all arts organizations which you or any members of your household are currently associated and the associated relationship." That's the whole question. And so Mr. Cheek completed this online form, according to what it says, is July 20th, 2023. So the deadline to submit this form was July 20th because that was the day that the first vote happened in July. So the commission members have to submit this annually before that vote. So what he said to that question, and this is quote, "Legal counsel to Oz Arts, Cheekwood, Symphony, Frist." So that was what was submitted on July 20th, 2023 to whomever on the staff manages that process. So the way that I obtained that was I just asked the staff, I said, "Can you please send me all of the information that commission members submitted to you for this year?" And then just the third thing that I would add on this topic of information that I collected is that I did an interview with Mr. Cheek on December 29th, 2023. It was on Zoom. I was alone. I believe that he was alone on his screen as well. And these were good faith interviews. They're not under oath. They're part of our fact-finding process is what we called it. And so when I asked him what conflicts of interest he has in discussion of how they implement the conflict of interest policy, he named these organizations: Belcourt, Cheekwood, Nashville Symphony, Country Music Hall of Fame, Frist Art Museum. And I can read the full quote that he said to me. So he said, "I used to be the chair of Belcourt for a while. I am a lawyer and I provide legal advice to nonprofits. Sometimes I get paid, sometimes I give it away. I have done nonprofit consulting with arts organizations. I recuse myself for that. I do liquor law. Most recently, the recusals were all arts groups I provide nonprofit advice to about their liquor licenses: Belcourt, Cheekwood Symphony, Country Music Hall of Fame, Frist." I've talked to all those organizations about their licenses in my capacity as legal counsel, and I haven't charged them. So those are the sort of three sources, I guess I would say, that I collected to review what Mr. Cheek has disclosed. So in summary, what he submits to the clerk, what he submits to the staff, and then what he told me verbally.
One more question. Can you speak to the voting records as well?
Yeah, and so I wanted to be able to just explain how the voting works and to answer any clarifying questions. And so in the report, it's kind of a two-step process for voting in 2 different months, right? So, and tell me if I'm off. I'm going to stick to my notes so I stay on track. And so there's sort of 2 steps to voting. What is the sort of framework of the funding policy? And so those are the scenarios that you probably read about in the report, scenario 1, 2, 3, 4, A, B, C, D. Those are what determine the amount to organizations based on their size. And so however you vote would essentially, whichever one you picked would determine, you know, this organization might get a grant of $50K or might get $100K. Just for an example, I'm just throwing out 2 numbers, right? So the scenarios are, what's the framework for the funding policy? So all commission members deliberate and vote on that. And then once that framework, that scenario is approved, you do the allocation votes. Do you have a question?
Yeah, I do.
Yes.
So the policy vote,
Yeah.
once the policy is voted in scenario A, I'm looking at page 26, it looks like it's then determined, the amount that an individual organization will get is determined by the formula. I'm looking at page 26, so that once scenario A is voted in, then what the large organization, it's all budget determined, what
Yes.
the individual budget is, will determine the grant.
Yes.
So it's not clear to me at all, I mean, so it's really voting on the scenario is the whole thing, because it
Yeah.
then is determined what the micro, small, mid-size, large are going to get, because that is the formula. It's no longer discretionary. This is what I'm not
Yeah.
understanding. Is that true? It's not discretionary at that point.
By discretionary, do you mean?
It's fixed. The amount of the grant is fixed by the specific budget of the specific organization based on the formula for funding.
Right.
Is that correct?
Yes, so the different scenarios are, you might have 50% of your organization budget funded, or you might have 12%. I'm making those numbers up.
No,
right?
you have it very clearly set out
We can
on
use the
page
numbers.
26, which I will refer
Yes.
folks to.
So that,
But I want to make sure I'm understanding how the vote worked, which is what you're explaining now.
yeah, and so, I'm just telling you what happened, right?
Right.
Every commission member deliberated and voted, or was eligible to deliberate, right? And eligible to vote. So there were no recusals by policy on those votes. So I would say, that is the consequential vote that determines the grant amounts
Right.
that organizations are eligible to receive.
Right.
And then, once that is approved, it moves into the allocation votes.
I guess that's where you were, and that's what I'm questioning. What is an allocation vote? I understand that it's the list, you have the large, this is what they'll get, but what is the significance of the allocation vote
Yeah.
once the formula has been approved?
Yeah, so I think the wording that I used in the report, to stick to my own language, was that it is procedurally necessary to allocate the funding, right?
It's a procedural thing.
And so, in July, so the first vote, and I'm talking about the two votes in July and August because that's where the discrepancy is in the recusal. In July, after the scenario was approved, scenario A, commissioners voted to approve allocations using that framework, category by category.
Right.
So the chair would read, okay, is there a motion for approval for micro-organizations in alignment with scenario A? And what she did in July was read each organization into the record.
She read the names of
Yes.
each individual organization.
Yes, and I will note, the July commission meeting was not recorded on YouTube. However, through a request, I have received an audio recording of it, and so that's cited in my report where the source comes from, the audio recording, although it's not available to the public unless you request it.
So, and there was a vote per size category, not per individual arts organization in July? Or was it by category? So she'd say, let's start with small, and would read the names of the art organizations whose budget meant they were in the small category. She'd read them. Did they take a vote per? Collectively per size, budget size?
A motion to approve small
Yeah.
organizations.
Okay. Yeah.
Motion, second, move on. A motion to approve organizations in the medium category. A motion to approve in the large, et cetera.
So a commissioner would not say of these, and what number of organizations are we talking about that gets grants?
There were 88 organizations and 131, or I think 131 individuals.
With under the Thrive umbrella, okay. So I'm sorry, you just said how many?
88. 88 across the
88
categories.
So a commissioner would not vote to, if there's, I'm going to make up a number, 15 small organizations that are eligible for grants. The
Yeah.
formula's been selected. Commissioners are now, in July, going through, and Chair Powell, was it?
Yes.
Was reading the names. It was just to let folks know who's in the small, but then the vote is just the category. So commissioners were not saying, this small, I'll vote no for that budget, but this small organization, I'll approve. It wasn't that way.
So you're recusing from all of them. Can I read? I'm just referring to my own notes, not a source. And so this is July. The recusal instructions were as such. Chair Powell stated, if you have a fiduciary relationship, if you're employed or on the board, or someone in your household is on the board or employed, or a contractor, or that. Metro Legal representative at the meeting that day, Tessa Ortiz-Marsh, then said, conflicts of interest are fiduciary, yes, direct COIs, but if you know internally that you have bias because you have a friendship, because you know you cannot take your self-interest out of the vote, and only you know what your self-interests are, then that is a scenario in which you should recuse yourself. So those were the two verbal instructions.
In July.
In July.
Okay.
And so the recusal from the allocation vote is really, self-determined, self-reporting where you recuse. And so on page 50 of the MHRC report shows the two ways that I constructed the chart from these meetings showing recusals. And I will say, again, this is in the audio file, which is cited in my report. In the audio file of the meeting in the July meeting to approve mid-size organizations, Mr. Cheek said, "Can I vote here? I don't think I can." And then Daniel Singh, you can hear him in the recording. I believe it's only audio, but I believe he is saying to the minute taker, the note taker, Janet and Will recusal. And so that's where the recusal happened for the mid-size organizations in July. which, matches the matches the form that was submitted online on the submittable platform about an organization that was in midsize. And so this is all self-reporting. This is what he self-reported in July, both electronically and verbally. And then in August, the sort of procedural difference was Lydia already referenced it, but instead of reading every name out loud for the organizations in each size as Chair Powell did in July, they just referred to it on the screen in August. So that was the only procedural difference, but otherwise it was the approval in each category. Clear as mud.
Although there was a delay in August for reminding folks of recusal and abstention, as you note on page 50.
Yeah, so you see there were no recusals in the first 4 categories, and that is a procedural error, and this is described in the
Yes.
box here,
Yes.
that the chair omitted by mistake, I assume, to call for recusals for those first 4 categories. And so that was a procedural mistake, yes. And then she did called for recusals, but they called them abstentions for the midsize and large categories. And so, the discrepancy is, again, when you compare Mr. Cheek's midsize in this category where he recused on the top of the page and not on the lower chart. And that is what I prepared to share. So I'm done unless there are questions.
Any other, okay. So then, now it's,
May I ask a question?
yes, go ahead.
In your interview with Mr. Cheek, did he address the Ozarts-Nashville relationship at all?
No, he did not.
Okay, are there any, from the board, are there any questions of this witness before we move to cross-examination by counsel for Mr. Cheek? Okay.
Thank you. I just have a couple quick questions. What were the recusal instructions in August? You mentioned what was read in July. Was that same statement read in August?
I believe, let me see. Do you all have in the minutes for the August meeting? I didn't have a printed copy.
We have the minutes for the August meeting.
I think the August meeting may state there.
I didn't see what you
Okay.
reported for the July meeting in the August.
thank you.
I think Lydia read the transcript, or was that?
Yeah, just like the
Sorry, am I-
projector and then going.
Okay. And then going off Mr. Spragan's question, all of the organizations in your interview with Mr. Cheek that he mentioned, do those fall within the large category?
They do. So the discrepancy, that's not what you're asking me. So what he told me in the interview, yes, were
Okay.
large organizations.
And did the Human Relations Commission report determine that if an organization is listed on a disclosure at one point at some time, that means a recusal is mandatory for anything related to that organization in the future?
I wouldn't say that our report made a determination about that. So what our report did do was say, this is the department policy, fill out this form. Mr. Cheek filled out the form on July 20th, enlisted Ozarts, and then they followed the instructions as I read by Chair Powell and Chair Tessa Ortiz about recusals. And so this was just our fact-finding report, so we were just presenting
Okay.
what the facts were.
Thank you. That's all I have.
Okay. Any redirect? Any clarification? Okay.
Can I ask
Yeah.
a clarifying question? Okay, I just want to make sure that I'm tracking. So the issue, as I understand it, is Commissioner Cheek disclosed some affiliation with some organizations, including Oz, on July 20th. and then he recused himself on the vote as it relates to those organizations' category, correct? Like, the organizations that are in the mid-size and the large category, he had some connection to those organizations that he did disclose, and he recused himself. Okay, and so then in August, which was the next month, okay, there was no disclosure of, like another disclosure? Was there an opportunity for another disclosure that he didn't do, or was it just?
The form that he completed on July 20th is just once annually. And then the, when they take the vote, commissioners it's always self-determining what you are going to disclose, right?
Okay.
And so that's, but the form was only completed one time, only required annually.
Okay, and so then when it came to the August vote, Commissioner Cheek did not recuse himself from any of the categories that were eligible for voting?
He did from large.
Okay,
the
that's
large
what the abstain means on the chart? It should be recusal?
Yes, and I would say that was I'm a layperson, I would call it a procedural error.
Okay.
They were marked as abstentions, where in the previous month they were marked as recusals.
Okay.
That could,
So is the problem that he didn't recuse himself from the mid-size category in August?
My observation when I was reporting the facts here is that a reasonable person would assume that the same recusals would apply the following month based on information he presented in July.
But this accurately reflects that he did not recuse himself in August from the mid-size category.
That's correct.
But he had previously disclosed and recused himself in July.
Correct.
Okay.
And can you just remind us how it was recorded? The lack of recusal for mid-size in August. Was that by voice vote?
It was by voice vote, yes.
And you were able to, I watched the meeting on YouTube. You were able to determine that he...
Well, it's also in the minutes for that meeting that were approved by the board. So if you look at the August 17th minutes of the Arts Commission, I don't have it in front of me. I do believe that they list recusals.
Usually you have the
that
minutes
though.
for August. And who takes the minutes?
A staff member. At times they have included the staff member who submitted them, and at times they have not. I don't know without looking at it if it includes someone's name.
And the person recording the minutes would be, is not here as a witness, right? Okay, yeah.
I see the July minutes, I'm having trouble finding the August minutes.
They're right behind the, I have them. They're in the submission probably for this hearing, August 17th minutes.
Okay, well, they're not in my printed copy, but I can look.
They're also on our report for Mr. Cheek. They're one of the exhibits on the report, if you have that.
Thank you.
So that's tab 4.
Before we leave you, Sue, there may be more questions. I do want to follow up on this, on these instructions from the July 23. It was the legal counsel who was assigned to the Arts Commission that distinguished between a direct conflict of interest and bias, question of bias, whether there is impairment of independent judgment such that the commissioner would recuse rather than take that vote. And that's an independent judgment.
Yes, that was
One makes.
Tessa Ortiz Marsh.
Tessa
who
Ortiz said
presides
that,
over
right.
the-
And if Tessa Ortiz explain that to the commissioners. That's how it works. Are you aware of there being, is that a new policy, or do you have any reason to believe that that hasn't been the way conflicts of interest have been discussed at the Arts Commission since 2019, for instance? Do we know anything about that? Like a reimagination of what conflicts?
I'm not sure that I'm able to speak to past
You're not.
practices.
So
Yeah.
you're not aware that that's a new thing or a new way of looking at it?
I mean, I know that Metro Legal does, as I understand it, an annual conflict of interest training or refresher with boards and commissions. And yeah, I'm not, yeah, I can't really speak to what happened outside of.
Right. Have you reviewed the Metro Legal's training materials on conflicts?
I did not review the most recent one that they did. Many of their meetings were not recorded and such, so obtaining some of that was difficult.
And there's not a written instructional materials, educational materials for boards to understand how conflicts, bias, impairment of independent judgment, standards of conduct, there's nothing written that you were able to review to develop a,
Yeah,
understanding.
I don't have that information in my process. I asked every commissioner individually in my interviews with them, how do you understand the conflict of interest policy and how is it implemented? And so I was really looking at it from what commissioners understood and comparing it to what happened in meetings.
Okay. And was, I'm sorry, I don't remember Tess's last name, Attorney
Ortiz.
Ortiz. Was her description of how to think about conflicts of interest consistent with generally what you were hearing from commissioners? Or was she in left field?
So there were, I'm not sure that it's
You may
appropriate
not
for me
know.
to
You might not
describe
know.
what other
I
commissioners.
can't answer that. That's fine. I was just.
Yeah, I mean, I can tell you what Mr. Cheek said in his interview with me if you want, because I have my transcript from my interview with him.
I'm really thinking about what all commissioners understand and policy issues and how it's thought of.
I mean, I think
On the Arts
broadly, most
Commission.
people would describe that conflict of interest policy is that if you have direct sort of involvement, then that's when you step back from deliberating and voting on issues.
Direct, I think it's a direct interest, direct financial, fiduciary, or financial interest. That's a direct conflict. But in addition to that, you'd want to think if there's some relationship that could cause bias and impair independent judgment on a vote.
That's the way it was described.
Okay, thank you. I really appreciate your patience with my questions. So, okay, yeah.
I have a question. I'm not calling into doubt your description of the August 17th mid-size vote, but I think the August minutes don't show any abstentions or recusals on the mid-size vote. Only on the large vote do I see 4 recusals, which is consistent with your chart. So is that something that you noticed when you looked at the minutes, that it didn't record the 3 abstentions that I think you found on the YouTube video?
I'm going to refer back to the note that I wrote at the bottom of my chart, and I will say there are inaccuracies that we've noticed in other places in the minutes, and so that could be one of them. Let me see. Yeah, so I mean, on page 50 and 51, the way I described, the minutes do not include a record of individual commissioner votes on those allocations. And I do say that this chart was constructed by my viewing of this recording based on, you see people raising their hands and you hear either whoever is sitting next to the recording microphone telling, who is recusing and who is not. And so part of my process, again, was comparing primary sources to the minutes and just looking at what I present as the facts. So this is what I presented.
So I do want to follow up just to make sure the record's clear. When I asked, because I watched the August meeting, and it wasn't clear to me, but my hearing's not great. So, I understood that the answer was they're recorded in the August minutes. Did you find them recorded in the minutes?
It doesn't have the individual votes, unfortunately. It just says the motion passed.
Right, we don't see any evidence of how former Commissioner Cheek voted in the August 17 meeting on mid-size. We have your report. Your report very clearly says there was some confusion in terms of the early votes. So, again, it may not be a contested fact. I think it's probably not.
I think Mr. Cheek acknowledges that.
Yeah, it's not maybe it's not a contested fact.
Yeah.
But I just, and we can hear whether we have certainty one way or the other. But this, I think, is very helpful because it's zeroing in. So are there any other questions of this witness before we thank her for her attendance? And did you have any thought? You asked your question, and there's no redirect now that we've asked her more questions. No redirect? Okay. Then thank you very much. We'll ask, do you have another witness that you'd like to present? No. Okay. It is time for respondent's case.
Okay.
Chief.
Thank you. As is mentioned, there's one issue before the board. For good or bad, this is a legal proceeding. The allegation is a violation of the standards of conduct, which is part of the Code of Laws. So words do matter, and we have to look closely at the words to determine whether there could have been a violation. I would first note that, as has been discussed, the chair at the August Arts Commission did not ask for recusals when the vote was taken, unlike July. So that's just a fact to be considered. Second, if we look closely at the standard itself, subsection O, the key phrases are accept other employment or engage in outside activities. That implies an action that is taken while a board member is serving as a board member at the time of the vote. Just for purposes of the record, I'd like to go through a few things, a few parts of Mr. Cheek's affidavit, just to get that on the record. If you look at his affidavit, starting with paragraph 5, I have not provided any legal advice nor had any affiliation with OzArts since 2021. Paragraph 6, I was not pro bono legal counsel to OzArts or any other mid-sized arts organizations at the time of either the July 20th or August 17th commission votes. Paragraph 7, I did not serve on a board of directors of any of the organizations that were awarded funding in 2023 and was not employed by and did not have any relationship with the mid-size arts organizations that were awarded funding. So from a legal standpoint, it would be impossible for his outside activities or employment to have unduly influenced his vote in August because he was not affiliated with any of those mid-size arts organizations. I think it's important to consider how that phrase is worded in the code. It does not refer to past relationships or past employment. It says accept or engage in. And Mr. Cheek did not do that. There couldn't be a violation of that standard.
Is it appropriate to ask questions now,
Yes.
or are you?
Yes, absolutely.
Okay. So why did Commissioner Cheek disclose those relationships in July and recuse himself?
I don't know why he disclosed Oz, but he didn't have to. I think that's the key point. And disclosing something does not require that you abstain on any future vote that might relate to that organization in the future. It's a case-by-case, fact-by-fact decision at the time. And at the time he voted in August, again, there was no request for a recusal, but the minutes do show that there was a vote. He could not have been violating this standard at the time of that vote. That's my point.
Is it your position that a commissioner doesn't have to recuse themselves unless asked before each vote?
I'm just pointing out that there was a request in July that was not in August.
So what does that mean? What do we do with that fact?
I think that adds to the confusion that was going on at the time of that vote, which, as the chair said, if you watch or listen to the meeting, it was not a picture of clarity as they were going through that process. But from a legal standpoint, he was not required to recuse himself because he did not have a direct conflict of interest. There was no fiduciary relationship. There was no fiscal relationship, nor was he engaged in any activity or employment with any of those organizations at the time of the vote. So whether he chose to or not is really immaterial from purposes or as it relates to these standards of conduct.
And do you have any knowledge or information as to a change in circumstances for Commissioner Cheek between the July disclosure and recusal and the August vote?
I do not. He had not had any relationship with Oz since 2021, so there was no change.
So again, you don't know why he disclosed those connections and recused himself in July?
I do not.
Anything? Nothing else?
Do you have any, can you speak to the lack of disclosure on the January 2023 forms that were submitted to the council committee, which may or may not be something that we're going to take into account today, but do you have any response to that information that was shared in the Human Relations Commission report?
No, at the time of the I guess that was a reappointment. I think the question is, are you engaged? I don't remember exactly what the wording of that question is, but he indicated that it was not applicable because there was nothing that he was doing that would impact his ability to serve. Now, as he acknowledged in the interview and during the council committee, special committee meeting, if a particular board member has a conflict of interest, they abstain. And frankly, I don't see a difference in a recusal and an abstention, but in any event, so he clearly knew when it was a requirement to abstain. And here, it was not a requirement.
Can I ask one more question for background? So Commissioner Cheek, is he a member of the Cheek family that is associated with Cheekwood?
That has been reported, but I honestly do not know.
Okay.
We heard in the case in chief of complaining about the Nashville Children's Museum, Nashville Children's Theater. Do you, and there was a comment that it was maybe a mid-size, or well, I don't know what it is. Do you have any information for us on that?
Sorry, I do not.
Okay.
Do you know if before Mr. Cheek resigned from the board, if he ever amended his disclosure that he filed in July of 2023?
I don't know.
Am I allowed to ask questions? Or wait?
You think? Yes, well, let's see where we are. You were giving your,
This is just argument, isn't it?
Yeah, it's just argument. He's
Well-
not presenting a witness.
well, we didn't, I don't know that we gave, well, let's think about this for a minute, because the respondent's not here. Respondent sent counsel. I don't know that closes off complainant's ability to ask counsel questions.
Well, I guess.
He's not just, we're asking him factual questions also. He
Right.
brought in an affidavit, I'm thinking, and I'm.
I think for purposes of clarification, it would be appropriate for the complainant to ask questions about the respondent's affidavit,
Right,
since that's
right,
the
right.
testimony,
Yeah,
so to speak,
exactly.
that's before us.
Yes, because yeah. So if it relates to the affidavit, yes, please.
I'll let you keep questioning, I'll
Okay.
reframe my questions.
Okay. Other questions?
Can I just make a note?
Yeah.
Or a statement? I mean, when we look at our procedure and then presentation of evidence, it talks about cross-examination, and you cannot cross-examine an
Counsel.
affidavit.
Right, right.
So I think it's a problem that Mr. Cheek is not appearing live to be cross-examined. I don't know if, I don't think we've had a hearing where the actual respondent did not.
We have.
I mean, since I've been sitting on the
Oh,
board,
yes,
is what I'm saying.
we have, the board has
Okay,
sent counsel in.
okay. And what have you done in that circumstance? As far as, again, a cross-exam, because I think it's difficult.
It is difficult, and it's something the board takes into account
Okay.
in our deliberations
Okay.
and our understanding of the evidence.
I would note that Mr. Cheek had a work conflict, and rather than trying to reschedule the hearing, he just asked me if I would appear on his behalf. And we do believe that the affidavit that he submitted under oath
Yeah.
addresses the question.
Yeah. I think one of the challenges maybe from an evidentiary perspective is that there does seem to be inconsistencies and moving things. The records are a little curious. And were he here, obviously, we'd be able to ask him what he was thinking. Did he hear the question? Was he attending to it? Did he? So that would be best evidence for us to understand what happened in the August meeting. That said, we'll work with what we have, and the affidavit's clear. It sounds like there's no cross-exam questions on the affidavit, but it is the state of the evidence that we're given, that we've been able to take in, and we'll work with what we have.
I'll just note that there was a question, like in the vein of a cross-examination of the affidavit, but counsel did not have information to answer it, which is, why did Commissioner Cheek disclose conflicts and recuse himself in July, but not in August? So just so that's clear, we don't know the answer to that from the affidavit.
Yes. Any other questions for counsel? Mr. Cooper? Okay. So before we go to closing, do you have a rebuttal case? Okay, so before we go to closing, I have one question, actually, I'd like to ask her.
Wait, rebuttal to his statement?
Excuse me?
Rebuttal to his statement?
It would be a
Or
rebuttal,
to the
yes,
affidavit?
yeah, to what was presented by respondent, yeah. Ms. Batchelder? There is one chart that, in your report, that has NA. There's actually the December vote establishing equitable funding formula. So it's got, and I know there's a lot of words here, and words matter. We have abstain, we have recusal, we have absent. What is NA
So
stand
on
for?
page 28, just to
Yes.
be sure.
Yeah.
NA just means that member was not serving at that time.
Okay, that's what I thought, but I just wanted to make sure they were not appointed yet.
Yes, yes.
All right, are there any other questions of, before we go into closing argument, any other questions? Yeah.
This is a question for Ms. Youssef or Ms. Batchelder, whoever is able to respond. Other than Mr. Cheek's July 2023 disclosure of Ozarts Nashville as a potential conflict of interest, do you have any other evidence of Mr. Cheek working on behalf of that organization during July or August 2023?
I don't have subpoena power, don't have time to investigate, so no.
It is a real limitation of this committee process that people can't really force an adverse party to participate in it. Maybe it's something we can talk about sometime, but thank you.
I guess I will just ask a question related. Is there any evidence that you have or any reason for us to believe, any facts and evidence you have to suggest that the vote on August 17 of 2023 by Mr. Cheek had any impact on anything? It wasn't, I mean, is there any reason to believe it had any impact?
I think it's part of a series.
Okay. But it's not that it changed, it's not that whether the recusal or not, vote or not, it didn't change any grant amount. It didn't change any grant amount.
Between July and August.
No, I'm talking about the vote on August. The vote before us is the inconsistency, but that inconsistency did not change any, did not affect any grant to any organization or individual Thrive artist. The inconsistency that we're looking at, right, did not have any.
So the voting did not, but
Okay.
the inconsistency with reporting who he's affiliated with, to me, impacted the defunding. So his
Okay.
conflicts of interest brought him to go to Metro Legal, told them to rescind the vote because there could be a lawsuit and there was a closing
So I
date.
think, I don't want to, but I understand what you're saying, how you're putting it together, how you're threading it. Okay, I understand that. Okay. Any other questions? Okay. We can
So
move
we
to
wouldn't
closing.
even have had this vote had there not been a conflict of interest, is what I'm saying. August would not have happened,
But
it would have been sealed in July.
But July, he recused himself,
Yes.
so there's no problem.
Yes. It's what happens after that vote with the conflicts of interest that defunded 131 people.
Okay, well, yeah, so you now may go into your closing.
Okay. All right. Thank you all for bearing with this. In a democracy, accountability is an implicit tenet. Accountability is not only those who we choose to rule and represent us, but also how. When a council member goes against the wishes of a community, for instance, favors a developer, communities can vote that council member out. There is an easy and accessible means for accountability for elected officials. People can go with as little burden of proof as much as, I just don't like them, don't like the way they talk, or they could go as large as, they destroyed my community and they led to the gentrification of my community, to outvote them. With boards and commissions in Nashville, unfortunately, with community members not having the ability to go and investigate, to go stalk and see who they're speaking to, what dinner parties they're going to, I also have a job and I also have things that I could be doing right now, but I am prioritizing my community and how important this is to them, that there is an accountability measure set in Metro Nashville. So for commissioners, we have two options. You can either go to Metro Council to try to get 30 out of the 40 council members to remove a commissioner, which takes a lot of advocacy work to go in, and that's what was being done to Will Cheek at the time when he resigned. Or you can go to the ethics board if there's a complaint, and then you have to learn to be a lawyer in 2 weeks. Yet, these commissioners wield so much power. They are wielding power over millions of tax dollars, and they decide which neighborhoods this money goes to. Primarily for the Arts Commission, for decades it's been downtown and not Antioch, or not Madison, and which they don't. Who becomes a director and who gets to set the vision and who doesn't. Whose culture survives and who doesn't. During the August 17, 2023 meeting, there were 2 hours of public comments which are not on the record. I spoke, I did a 10-minute public comment on what it meant for my community to be defunded. I had collected stories of kids who didn't even know you could be a songwriter in Nashville, in Music City, because they couldn't even imagine that. Their parents are factory workers. And we were going to fund that program if we had gotten the funding. We had factory workers who are oud players, who are women. That's very atypical in our community that I spoke to. We had international writers that we wanted to bring who called Nashville home. We had papyrus artists who wanted to share how to do that artwork here in Nashville, and they all got defunded because their art was not seen as worthy to the level of the ballet and the opera. So I'm asking this board to heed the call of the people for accountability and to make sure that there is a record on this commissioner for the harm that he has done to the Nashville community. I'll end with 2 quotes. Stokely Carmichael said, "If a white man wants to lynch me, that's his problem. If he's got the power to lynch me, that's my problem. Racism is not a question of attitude, it's a question of power." When the Pharaoh was asked, "Why did you become such a tyrant?" he said, "No one stopped me." So that's what I leave before you all.
Would you like to make a closing argument?
Yes, briefly. With all due respect, equity of arts funding and arts funding policy is not at issue here. So that is not before this board, whether things were done equitably or organizations were funded properly. The question is whether Mr. Cheek's actions or inactions on August 20th could or were a violation of the standards of conduct, and we submit that they simply could not be and were not. Thank you.
Well, thank you. So the evidence is in, the arguments are in. I will say before we move to deliberations, I do want to say the amount of work and effort that went into this is really obvious and visible to, I think, all of us, the amount of work put into the complaint. And I personally appreciated even the referring us to the minutes and a video. I know we're a hard-working board that takes this very seriously and really works to educate ourselves on the issues before us. And this, because it was meetings, we really were able to review a lot of material, including this very well written, very well put together report from HRC. So thank everyone for that, providing the information to us. I also just want to say just a note before we go into deliberations, these are the issues that the complainant is raising and bringing to us are very key, important, and arguably urgent questions about who we are as Metro, as a community here in Nashville. The importance of what has been raised generally, the larger context is very key and apparent. I think we all understand watching videos and educating ourselves about the details of what's been going on, understand that this has been a very difficult, painful experience for our city and our community generally. Arts funding, issues of equity, the human relations issues, I mean, the whole thing. So this is my view, and because these are such important, larger questions that I just wanted to say that and, invite anyone to share their thoughts if they wish along this, as they see it. And then we will kind of focus on the work of deciding this particular complaint that is before us. But again, given the significance of this discussion, the context in which the complaint arises, I thought it was worth stating that. So, any thoughts or any desire to speak before we get into the specific question of the complaint? And that will, anything? Okay, all right, let's do it. We have the evidence in, and we have the standard before us, subparagraph O. The question is, engaging in activities that accepting other employment or engaging in outside activities which might impair their independent judgment in the performance of their public duty. I think the question that is standing before us, the count that we had stand and took evidence on, was whether the August 17 lack of recusal or lack of abstention on the medium-sized organizations, that vote constitutes a violation of O, subparagraph O. That's the question before us.
Mid-size, is that?
Mid-size.
Mid-size
What did
is
I
the
say?
term.
Yeah,
Medium.
mid-size. You're right,
medium
mid-size,
and
mid-size, which is right next to large, right?
Right.
Mid-size. That's the question. Did former Commissioner Cheek, the respondent, accept employment or engage in outside activities which might impair his independent judgment in the performance of his public duty as an arts commissioner, voting on August 17 on the allocation approvals in alignment with scenario 4 as to mid-size? We see from the record, yeah, so that's the question. Thoughts?
Can I ask a question of Metro Legal?
Yes.
Are we limited to finding today that subsection O was or was not violated? For example, if we found a different provision of the Ethics Code, subsection R, or the disclosure requirements in 222030 were violated, would that go beyond our mandate for this hearing?
I would refer you back to the order that followed your previous meeting on April 4th.
My only concern with raising a whole new thing was it feels like it's not really giving respondents or counsel, the opportunity to provide information.
That's why I was just asking.
Yeah, I mean-
I'm assuming that we're limited because that subsection is in the order, but I just wanted to get some clarification.
Yeah, and we have the minutes from our April 4 meeting where you moved.
I know what happened. My question is a little bit, which is,
okay.
would we violate someone's due process if we found another provision of the code was violated? That's
Yeah, I
why I'm
don't
asking
know.
the
Okay.
lawyers.
You risk doing so.
Okay.
I think you would have to give the.
Notice.
Yes, notice and an opportunity to respond to it.
Okay.
Now, I'm just really looking at what our action was. We moved to dismiss the first two allegations, but sustain the third allegation regarding a potential violation of Metro Code of Laws 2.222.020, subparagraph O, which was seconded and voted unanimously for. So we did have a very narrow vote. Thoughts?
I'm referring back to the Department of Law report that we received with an opinion from Metro Legal about this complaint. And page 9 of that report summarizes the allegations in the paragraph right before the conclusion section. And it references the allegations from the MHRC report, which state that Mr. Cheek's engagement with other arts organizations as a board member or legal advisor impacted his actions as a commissioner. The allegations include Mr. Cheek's inconsistency in recusing or abstaining from votes that concerned funding for organizations with which he was associated as pro bono counsel or board member. In particular, he disclosed in July 2023 that he provided legal advice to a mid-sized organization but did not abstain from the vote regarding the mid-sized organization funding in August 2023. And it states these allegations, if true, could
with scenario A, is what I take from this material, this vast material submitted to us as members of Nashville have, heard about, heard about, is going to be somewhat different. So this has been, again, all the work that's gone into the complaint and all of the materials provides this huge landscape for us to think about policy questions and all this stuff. The question you raise, is that before us? I hear what you're saying is that conduct, the allegation, I watched a video. So again, this is where we may have different information depending on whether we watch the whole video or not, all of us on this board. I definitely saw a video with the legal director saying commissioners call him frequently when they have a concern. What we don't know is whether former Commissioner Cheek raised the SCOTUS decision in the July meeting. I don't know that, whether he did or not. The SCOTUS decision was big news. I live in a realm where it's big news, and it messed a lot of things up. I mean, its ramifications is still causing a lot of disruption. So the question you're asking is, do we factor in, because we saw YouTubes or watched, that there's a sense that it's alleged that, and I don't know that it's disputed, I agree with you, that Mr. Cheek contacted legal to say, I'm concerned that this vote we took in July will be found unconstitutional and cost a lot of money for us to defend. This is the challenge for this board right now. It's very challenging because we have all this information, all these allegations, all these characterizations, all these accusations, all these complex questions, inherently really difficult questions. And we voted a few weeks ago that we were going to look at O, subparagraph O. When he failed to recuse himself in August, was it because he was engaging in activities that were impairing his independent judgment as to the vote on August 17? And that's what I can't see. I literally can't see it. I see the inconsistencies. I see the frustrations that he's not here to answer our questions. I see many things presented, but I don't see, because I saw when I read everything, I see kind of consistent judgment. In fact, one of the allegations is he's always voting against equity. One of the allegations is he was saying he was for equity. His resignation letter, and you saw the resignation letter, he it seems I heard him on a video say, he was interested in unifying the arts community and trying to get more money, and that was view of equity. I saw a video where an Arts Commission staff person said, everyone agrees we need equity. The question is, we don't know what that means. We haven't figured out as a community what that means and how it's operationalized. We are in an odd position because here's the thing about this board, we are governed by the code and the standards of conduct. The only place we get authority is with the code. Without the code in front of us, we're merely a random group of people who have opinions about what's happening in Nashville. So we are guided by the standards of conduct, the code language. And in order for, I think, in order for us to function over time with all the complaints that come before us fairly and thoughtfully, deliberatively, it's about what the code is saying. So I guess I'd need to hear how we know whatever his relationships were, that it was impairing his independent judgment. I need to understand that better, because that's the piece that's missing for me.
Can I try to
Yeah.
articulate my thinking, which I think is going to touch on some of what you guys
Yeah.
are talking about? So, I mean, what I understand Ms. Young to be asking is, is the only performance of public duty, the language from Section O, this vote in August of 2023, or might, as alleged in the complaint, calling Metro Legal and putting the ball in motion to rescind this, allocation, might that also be a performance of an official of a public duty? And I'm open to that being a possibility. It wasn't really emphasized in the presentation, which focused really more on the inconsistency in voting, but it was in the original complaint, and I think it's documented in the record. To me, the question is, was he affiliated with Ozarks Nashville during this time period when he was doing these things? And he has, stated and I regret that he's not here. I think that is a bad choice on his part, frankly, and that we could have continued this hearing because we all have a lot of questions. And a preponderance, I don't know what you do about that. He was here last time when we set the date for this hearing, and so I expected that he would be here today. But we do have his statement under oath that he was not affiliated with Ozarks Nashville or any mid-sized organization during that time period. So, for me, that's not been rebutted. We have, we don't have anything from someone at Ozarks Nashville saying, yes, he was coming to our meetings or giving us legal advice, pro bono or otherwise. And, I have questions about the fact that he disclosed it in July, recused himself in July, and then didn't recuse himself in August. And I wouldn't fault anyone for drawing a negative inference from that if they want to. To me, and the reason I asked that question earlier to Metro Legal is, there's a standard about disclosure statements, and they have to include all material information reasonably required to be included and not omit any material information reasonably necessary to make such reports complete and meaningful. And, to me, that might be what the evidence here supports, but that's not what's before us today. What's before us is, did he engage in outside activities which might impair his independent judgment in the performance of his public duty? And I can't satisfy myself personally that he did engage in those outside activities, even though there are questions about the disclosure and the recusal or the inconsistency in the recusal. So that is the way I look at it. And I also would say at most, the sanction that I would probably support if he had violated Section O in my mind would be to, request his resignation or recommend his resignation or something. And that's already happened in this case. So to me, while there are a lot of issues that go beyond the scope of what this commission can handle, I think there's a very close one on Section O, but I cannot personally find by a preponderance that he was engaged in an outside activity vis-a-vis Ozarks Nashville or some other mid-sized organization during that time period. That's how I'm looking at it.
just as kind of institutional knowledge on that one of the points you raised, this board has in the past found an ethical violation we have found technical violations without moving to the sanctions level. So I just want to throw that out since one does not determine the other.
And, sorry,
No.
I didn't want to cut you off. I thought that at our last meeting, the legal department advised that there were other sanctions available for a board member that is no longer serving on that board.
Yes,
So
there
there are
are.
other things that could happen aside from calling for that person to be resigned or removed from that board.
Right, our options are, I don't know if you want that, our options are to recommend a resignation, which is moved here. Send to Metro Council and ask that they be censured, publicly censured. Send it to the law department, basically for civil action, or send it out, refer it for criminal action.
Okay.
Very, very, very limited. Our sanction abilities are very limited by code. But even if we do not, there have been times when we have felt that something wasn't right, it felt unethical to us, but it felt was a technical unethical conduct, but didn't rise to the level of our options for sanctions. In one case, I believe, we just, said it was technical violation, but we did not proceed to sanctions. We're somewhat boxed in by the code.
Well, I don't think we have to, I'm not proposing that we talk about sanctions at this point before we find whether there was a violation. I just wanted to clarify since that was
Right.
mentioned,
And I
that
wanted
there
to-
are other sanctions available.
Right, and I wanted to make sure that our questions about sanctions does not interfere with the primary question before us, which is whether we can find an ethical violation.
Well, I still feel that in my mind there is enough to find a violation. If there are not enough votes to go in that direction, then that's fine, but I don't really have anything else to explain or justify that position.
Any other thoughts? Do you want to make a motion? Are we ready to, does anyone have anything else to, and then we'd be ready for motions.
Well, it sounds like there might be competing motions. One, it sounds like Ms. Carpenter and Mr. Spraggins may be in favor of moving to continue the hearing to allow for a respondent to appear so that we can get some clarity about the allegations that weren't addressed in his affidavit. So I don't know if either one of them wants to try that route, but otherwise, I don't know that we have the votes to support one outcome or another.
Yeah, well, thank you, that's very helpful. Does anyone have any procedural motions?
I don't, the more I thought about it, we can't compel Mr. Cheek, I don't think, to appear,
We
even
cannot.
if we were to continue it, so
We do
that's
not.
my, concern. And I don't want, I think the complainant was here and doesn't need to be required to appear again when she has put together all her materials and appeared. So I'm not gonna make that motion.
And as I've already said, I wish he showed up to answer our questions today. I don't see a need to prolong this process when we have not a full body of evidence. We don't have the answers to those questions. And I think commissioners can, as I said, draw inferences as they view appropriate from his, inability to answer those questions. But I'm not going to make that motion either.
Okay. So we are then going to move to decision on how we want to handle this particular complaint, having had a full couple of hours of hearing and deliberations. So that is the question. I entertain a motion.
Is it possible to just do a yes or no vote as to whether we believe there was a violation rather than,
Yes, I think that's a very good idea.
okay. I don't know how to phrase that as a
Okay,
motion.
okay, so but are you saying to move to vote on whether we believe there's a violation?
Correct.
Or were you saying like a straw poll just to see where we're all thinking? Or are you saying, oh, no, just?
I'm saying move to vote on whether we find a violation of subparagraph O.
And I'll second that motion, that we have a vote.
Yeah, I guess, that sounds good. I'm not aware that, as opposed to saying, I move to find a violation.
Correct.
Or I move to find not a violation, you're saying, move to poll the board members, well, move to, let's try it.
The motion is for this board to vote by saying yes or no as to whether there was a violation of subparagraph O.
Okay, and is there, and that will count as our vote on finding there was a violation or there wasn't a violation. It sounds like what's innovative here is that it's leaving it neutral in the statement. I'm looking at, yes.
I am not completely clear on what the motion is for. If it's simply, are we ready to vote? I don't think you're required to have a motion there. If it is, I would move for the board to find that there was in fact a violation or that there wasn't.
It's more innovative than that.
So we can't just vote
Well,
on whether there was a violation or not? You need a motion either finding there was or finding there wasn't?
yes,
Is that
but
what saying?
I think I heard you suggesting something innovative, and it may be insufficient from a vote perspective and an official, but I heard you saying that to move to, really it's a straw poll, really, to move to ask board members whether they think there's a violation or not. Depending on what happens, we might need a second vote.
I would suggest, if you want to do that without a motion, you could just go around the room and people say what they're saying, which is.
I'm understanding that it's neater and cleaner if we have a motion that is dispositive, like this is, it's clear what the motion is. A motion to find a violation or a motion to not find a violation is what is the preferred way to go.
Okay.
I kind of liked your idea. I thought it was very innovative. It might be.
I'll let somebody else make a motion.
Well,
But you could make a request.
I think if Ms. Young just said she'll let somebody else make a motion, so
Okay.
if there's not a motion to find a violation, I'll make a motion to find no violation under the facts that we've considered today.
Is there a second?
I'll second the motion.
Okay, so that is the motion before us. Is there any further discussion?
I'm sorry, is the motion no violation?
That's correct.
Thank you.
Any further discussion? If not, we'll take the vote by roll call.
Chair Tiani?
Yes.
Ms. Carpenter?
Yes.
Ms. Grimes?
Yes.
Mr. Spraggins?
Yes.
Ms. Young?
No.
It's 4 in favor, 1 against.
Okay. We have a quorum of 5, but we can take action with 4 votes. So we have 4 votes. So that motion passed. And it's an action of the board in finding, and the orders will issue in a few days to that effect. Given its result, or this hearing is completed and done. And thank you all.
Thank you.
For your attendance and your participation. That brings us to the next item on the agenda, which we have in the packet. Item number 6. The yellow items, that's what, thank you. Discussion and analysis of the amended complaint and Department of Law's memorandum re Joseph B. McCoy Arts Commission. As we do when there is a complaint and a memo report from Law Department, we typically we begin by asking the Law Department whether they would wish to summarize their report for the board.
Well, we're happy to do so. I know you've been here a long time this
Yeah.
morning, and you might prefer to skip that step.
Okay. Okay, then I will rephrase it and say, do any board members have any questions of the Law Department regarding their report of April 23, 2024? We summarized the report by saying that suggesting that a broad reading of the complaint and the could possibly support a violation of subparagraph K, and finding that as to the other subparagraphs of the code, the facts alleged would not support a finding of an ethical violation. I hope everyone's had an opportunity to review the report and all of the materials submitted. So, discussion. I guess I will ask the Law Department, in light of your suggestion that a broad reading of the complaint could support a violation under K. And K is actually, you'll all remember, K was the code provision that we discussed at some length last meeting. Thank you. That shall not give reasonable basis by their conduct for the impression that any person can improperly influence or unduly enjoy their favor in the performance of their official duties, or that they are unduly affected by kinship, rank, position, or influence of any person. Law Department is saying, in light of all of the allegations of the complaint, that a broad reading of it could support a violation of K. I guess I would ask if the Law Department wishes to explicate that a bit in terms of what kind of conduct could.
Well, in this particular case, I will do what I just suggested maybe there wasn't time for. But the amended complaint restates virtually everything that's in the original complaint. And for the same reasons that in our initial report on the initial complaint, we didn't feel there were sufficient allegations to support a violation, we stand on that. And then this board did dismiss some allegations related to sort of an open meetings violation. On this specific one, this particular provision of the code is not crystal clear, and it is subject to some interpretation too. And it's, in some ways, it reminds me a little bit of your discussion on subpart O. The board, to some extent, has some discretion in determining what these things mean. But we, in looking at it, felt that there were some allegations related to Ms. McCoy's treatment of large organizations and corresponding treatment of small organizations that could support a finding that conveys an improper impression that these large organizations are unduly receiving favor. So you can reject our recommendation and conclude that we're incorrect in our interpretation of the code on that point, or that what is alleged would not support a violation of the code as we have suggested.
And in terms of the analysis that law department had, it would be conduct beyond how one was voting, or would
Yes.
how one voted on these grants could be the,
Not the vote, but
not the vote,
but the conduct.
Conduct, so speech and things.
Yes. Well, speech, yes. Not the specific words that are said, but conduct that I guess you could argue might be speech in itself.
Okay. Okay. So the question before us is whether we wish to adopt the law department's recommendation or reject the law department's recommendation and go and dismiss the whole thing, or go forward on either the narrow code provision recommended, or we could go forward on the whole complaint. I think we dismissed the open meeting last month, so that's closed to us, but everything else is open. Everything else is open to us.
I guess I lean toward adopting Metro Legal's recommendation. I didn't see anything in the complaint alleging that Ms. McCoy was receiving, had a financial interest. So the standard J, I couldn't find support for, but I'm open to somebody else pointing it out. Standard K, we talked about a good bit at our last meeting, and I think this complaint does allege that Ms. McCoy was more sympathetic to larger organizations and more hostile to small organizations, and gave that impression in her public comments. And to me, that could potentially give rise to a violation of Standard K.
Okay, any other thoughts? Discussion? Hearing none, do you want to make a motion?
Sure, I'll move to adopt the recommendation of Metro Legal.
Is there a second? I'll second. Any discussion? The motion is to adopt the Department of Law's memorandum, which is suggesting that we go forward to hearing on the complaint against Commissioner McCoy on the grounds of examining whether subparagraph K might have been violated. Is that the correct statement of the
Yes.
motion? And it's, okay. So it's K alone. I don't want to get into the problem we had.
Sure, yeah, it's
So-
to dismiss J and hold a hearing on K.
Okay. Dismiss whatever else was there and just go forward on K. I want to make the record really clear. Okay. All right. So we have a motion, we have a second. Any further discussion? Hearing none, let's take the vote.
Chair Diani?
Yes?
Ms. Carpenter?
Yes.
Ms. Grimes?
Yes.
Mr. Spraggins?
Yes.
Ms. Young?
Yes.
Okay. So we will move forward on the McCoy complaint to hearing on subparagraph K. There will be orders issued to that effect. We now need to find a date in which we will hold that hearing. So I guess I'd ask everyone to look at their calendars. And I'm going to throw out to look at the end of the week of May 20th. So I will just throw out for discussion the possibility of Thursday, May 23, or Friday, May 24, starting at 9.
I will be out of the country
That week?
that week, and I'm returning to town on the 29th of May.
Okay. So this gets complicated. How's everyone else?
I'm out of town on the 24th, but I'm in town on the 23rd.
The 24th is the Friday.
I
Memorial
realize, yeah,
Weekend,
I realize.
so
Ms. Young, when are you out on the 20th? Are you?
Yes, I'm out
That whole
May 13th through the 27th.
Okay. And then I'm out, I'm out and out of country, out of state, and then is Wednesday, the 5th of June possible?
That's fine for me.
Me too. I'll be up, but I choose myself.
Yeah. Okay. Okay.
Yeah.
You're good for
Yes.
Wednesday, June 5? Yep. Wednesday, June 5. Okay. Let's say Wednesday, June 5 at 9 a.m. Okay. So we'll all be here. Okay. Great. So the order that we'll issue will have that date in it and time in it, and we'll be here, meet here. Okay. And that gets us to okay, that gets us to next steps in scheduling. As you all know, we have a new complaint, and we can, we'll hear, but we'll be meeting on June 5, so we'll put that on the agenda. Okay, any other next steps? We have our next meeting.
So the new complaint that just came through
Yeah.
is gonna be here on the 5th too?
It will be heard, no, it's the 5th.
June 5th?
Yeah. Because the 21, you have 14 business days, 20, so the report will issue in early May.
Early May.
May 7 or something.
Okay, I'll let
And then-
Nikki know.
Yeah, and then we'll hear it on June 5, your report, the preliminary.
Okay.
Okay, any other matters, any other discussion? Hearing none, motion to adjourn, may I have a motion to adjourn?
So moved.
Second?
Good.
All in favor, say aye. Aye. We are adjourned. Thank you all for all the work.